Yes, thank you very much, Mr. Speaker, and my thanks to the cooperation of the House for giving us some time to be able to actually read the amendment and take some stock of it. For those of you that are newcomers to the House, you were almost treated to the specialized official opposition drone on as we try to waste time through something until we've got enough time to read it. So by amending or by adjourning briefly, you weren't subjected to that, and I thank you for your courtesy in doing that. Although I have to say it was a bit unusual to have government amendments brought forward and us up debating them instantly. Usually there's an opportunity to present them and then adjourn and come back another day, or to table them during the earlier part of routine so that we've had a chance to look at them for a couple of hours. And then come into the House and debate them at night, or something else. But it's quite unusual to, first of all, not have an evening sitting where we weren't up to speed on staff and be expecting one parliamentary council to handle all of this, and then to have the amendments come onto the floor and have to debate them immediately. So thank you for that. Yeah, it actually was pretty unusual, especially for the last 4 or 5 years. I'm okay with this one, with the first one. What we have before us is A1, the government amendment to Bill 44. As per my request, we have severed the two sections for the purposes of voting. But essentially what we have is in Section A is dealing with the very controversial Section 9, which amends Section 11.1 of the original bill. And that was the section that has been commonly referred to as the parental opt-out section. Some people have called it a parental rights section. But this was the part that was new, and many, including myself, argued that, one, you shouldn't be doing it, and two, if you absolutely had to do it, you shouldn't be doing it in the Human Rights Act, because this section is giving direction to the school boards, in essence, and telling them that they, one, have to provide notice to a parent or guardian of a student if they're going to have any instructional material or teaching instruction in classroom time spent on a subject matter that dealt explicitly with religion, sexuality, or sexual orientation. And secondly, that if the school did receive back a written request signed by a parent or a guardian, that student would be excluded from that instruction, and the teacher would could not penalize the student academically, and that some additional alternative instruction would have to be provided for them to make up for that. And of course, what goes with this is that if this section was contravened, we're talking about the Human Rights Act after all, of course, then that gave the parent or guardian the opportunity to bring a human rights complaint against the teacher or the principal or the school or the school board. I think we have not even begun to comprehend what far-reaching rolling effects this section will have on our society as we know it. If you look at this from a parental rights point of view, this is something that a number of states in the U.S. have tried to get into their legislation and has been vigorously opposed. And here, with 72 members of a Conservative caucus voting, well, we'll see if it's a free vote, but it's quite likely that the government will be able to, with their majority, implement this into law. And I can see this having an effect on allocation of resources, both prioritization of services that are offered by government, depending on whether or not you fall under what is being assumed by this particular clause or not. The amendment that they're working on is to say primarily and explicitly, in other words, add in the word primarily and explicitly dealing with religion, sexuality, and sexual orientation, and a small change around human sexuality, which, in fact, I had an amendment ready to go that would have done exactly that, add the word human in front of the sexuality, because it had been pointed out to me by a number of teachers that it was very difficult to teach biology and some of the other sciences if you could not, in fact, refer to different sexes, because that's, in fact, how it occurs in nature. And you had to be able to talk about that, or it would be very difficult for a teacher to work in the classroom and actually impart that knowledge.
Relax.
So those two changes have been brought in, plus an additional clause that's added in that says, by the way, if this is an incidental or indirect reference to religion, religious themes, human sexuality, or sexual orientation, that it wouldn't have effect in the larger picture. So what we would have then is a parental opt-out section, which still would require notification. It would still be in the Human Rights Act, not in the School Act. Would still require notification to parents or guardians about the type of instruction, although it's now saying subject matter which would primarily and explicitly deal with religion, human sexuality, and sexual orientation. It would still require that teachers would be able to, on the written request of those parents and guardians, that they would exclude the student from the instructions. They would provide something alternative. And just to clarify that it would not, the subject matter primarily and explicitly dealing with religion, sexuality, and sexual orientation would not apply where this was an incidental or indirect reference. That amendment does not fix what is in this bill. And I think, in fact, to me, this clause is a perversion of what was intended by the human rights legislation, and even a perversion of what I think was originally intended by the minister and by the government, which was to strengthen the administrative abilities of the Human Rights Commission and to add in sexual orientation. And I cannot countenance this section. I have gone back into the communities that I deal with and have said, what do you want me to do? And essentially what I got back from them were instructions saying, don't do this. Don't support this. Here it is. Well, I would like to see sexual orientation in. I do not want to see it in at the cost of an opt-out clause. By expressly including sexual orientation in the legislation, they are taking back with one hand what they purport to give with the other. And I think that it also gives a larger messaging, where it was bad enough that we gave a message that the province, although it would begrudgingly offer the service of protection on the grounds of sexual orientation, particularly around housing, employment, and access to government programs and services, there was a sort of mega message there about, but we don't really like it very much, because they wouldn't write it into the legislation. So now they've done that, but then they've given them with one hand and taken away with a much larger hand. And to say, essentially, it's okay to discriminate. It's okay to have children not learn about certain kinds of people with this clause. And I just cannot support it. And I think many other Albertans can't support it. And as a result, Mr. Speaker, I have a sub-amendment that is at the table, and I would ask that it be distributed at this time.